Alan Jackson is off the case. Nick Reiner, the man charged with stabbing his parents to death in their Beverly Hills home 6 weeks ago, just lost his defense attorney. Not in a month, not after some drawn-out legal dispute, today. This morning, January 7, 2026, at what was supposed to be a routine arraignment hearing in Los Angeles Superior Court, Jackson is expected to walk in and tell the judge he's withdrawing. No public explanation yet. No statement from the attorney's office. Just sources close to the family confirming what everyone in that courtroom is about to learn. This is the same Alan Jackson who defended Karen Red. The same attorney who's built a career on high-profile, nearly impossible cases. He took Nick Reiner on in mid-December, right after the arrest, and one of his first moves was to delay this exact hearing. He asked for more time. He got it. And now, 3 weeks later, he's out. That's not how defense attorneys operate. You don't take a double murder case with special circumstances, which in California means the death penalty is on the table or at minimum life without parole. You don't take that case, delay the arraignment yourself, and then bail before your client even enters a plea. Unless something happened. Unless something about this case, something about Nick Reiner or the evidence or the situation, made it impossible for Jackson to continue. And the thing is, we don't know what that something is. The sources aren't saying. TMZ broke the story this morning, but they don't have the reason either. Jackson's office hasn't commented. The Reiner family, what's left of it, hasn't said anything publicly in weeks. So we're left looking at this from the outside, trying to figure out what makes a defense attorney walk away from the kind of case that usually defines a career. Because that's what this was supposed to be for Alan Jackson. A career-defining case. Rob Reiner isn't just any victim. He directed When Harry Met Sally, A Few Good Men, The Princess Bride. His wife Michelle was a photographer and activist, well known in their own right. When they were found dead in their home on December 14th, stabbed multiple times, and their son was arrested within hours, this became the kind of case that cable news runs specials about for years. The kind of case that gets a Netflix documentary before the trial even starts. Alan Jackson knew that when he took it on. So what changed? Nick Reiner is 32. He was living with his parents at the time of the murders, which some outlets reported immediately and others left out, probably because it complicates the narrative depending on which angle you want. Was he living there because he needed support, financially or otherwise? Was it a temporary arrangement? Was there tension in the house? We don't have clear answers on any of that. What we know is that on the night of December 14th, someone stabbed Rob and Michelle Reiner to death in their Beverly Hills home. The weapon was a knife. The charges filed against Nick include 2 counts of first-degree murder with special circumstances, the special circumstance being multiple murders, and an allegation of using a deadly weapon. He was arrested the same day. That's unusual unless the evidence is overwhelming or unless investigators believed he was a flight risk. In cases like this, especially when the suspect is a family member, arrests can take days or even weeks while detectives process the scene, interview witnesses, wait for forensic results. But Nick was taken into custody almost immediately. He's been held without bail since then. No bail was even requested at the initial court appearance, which got rescheduled to today. The delay was Alan Jackson's doing. In mid-December, Jackson appeared briefly on Nick's behalf and asked the judge to push the arraignment back. Standard move when a defense attorney needs time to review discovery, meet with the client, build a strategy. Arraignments are procedural. The defendant hears the charges, enters a plea, usually not guilty at this stage, and the case moves forward into pretrial motions and eventual trial prep. It's not dramatic. It's housekeeping. But Jackson wanted more time, and he got it. Then today rolls around. The arraignment that Jackson himself delayed. And instead of entering a plea for his client, he's withdrawing. The timing matters here. If Jackson had doubts about the case or the client, he had 3 weeks to figure that out. 3 weeks to meet with Nick, review evidence, consult with experts, talk to family members who might testify or provide context. Whatever he learned or experienced during that time was enough to make him pull out. And pulling out at this stage, right before an arraignment, is about the worst possible timing for Nick Reiner. Because now he goes into court today without an attorney. The judge will likely appoint a public defender temporarily or continue the arraignment again while Nick finds new representation. Either way, it's chaos. It makes him look unstable or difficult, or like his case is falling apart before it even starts. And maybe it is. There's been speculation since the beginning about what Nick's defense might look like. Mental health is the obvious angle. In California, if your attorney is planning an insanity defense or diminished capacity defense that requires serious expert evaluation, psychiatric records, a whole infrastructure of preparation, it's expensive, it's time-consuming, and it requires the defendant to cooperate fully with psychological examinations. If Nick refused that cooperation, or if the evaluations came back in a way that didn't support the defense Jackson wanted to build, that could be a problem. Defense attorneys can't knowingly put forward a defense they don't believe is viable. That's an ethical violation. But that's speculation. We don't know if mental health was even part of the strategy. We don't know if Nick was uncooperative, or if there was a funding issue, or if Jackson simply decided the case was unwinnable given the evidence. All of those are possible. None of them are confirmed. Here's what else makes this strange. Alan Jackson doesn't take cases he thinks are unwinnable. His reputation is built on defending the indefensible, on taking clients everyone assumes are guilty and either getting them acquitted or at least getting them a better outcome than anyone expected. Karen Reed's case was a mess from the start, massive public attention, intense media scrutiny, and Jackson stayed with it. So if this case was just difficult, just high profile, just controversial, that wouldn't be enough to make him walk. There has to be something specific. One possibility is a conflict of interest that didn't surface until recently. Maybe Jackson's firm represents someone else connected to the case. Maybe a witness or an expert or even a family member has ties to the firm that create an ethical problem. That would force a withdrawal, and it wouldn't necessarily reflect badly on Nick. It would just be procedural, unavoidable. But if that were the case, Jackson's office would probably say so. Conflicts of interest are easy to explain and they don't make the attorney look bad. The silence here suggests it's something else. Another possibility is money. High-profile criminal defense is astronomically expensive. We're talking hundreds of thousands of dollars, potentially millions if the case goes to trial. Alan Jackson doesn't work for free. Rob and Michelle Reiner presumably had significant assets, but those assets are now part of an estate, and if Nick is convicted he won't inherit. So who's paying for his defense? Extended family? Friends? Is there a trust or fund set up? If the money ran out or if there was a dispute over payment, that could absolutely force an attorney to withdraw. Courts don't like it when attorneys leave cases over money, but it happens. The records show Nick appeared briefly in court in mid-December, then that hearing was postponed to today. During that initial appearance he didn't enter a plea, which is typical when the arraignment is continued. What's not typical is your attorney leaving right before the rescheduled date. If Jackson had been planning to withdraw, he could have done it in December. He could have advised Nick to find different representation from the start. The fact that he stayed on for 3 weeks, asked for the delay himself, and then bailed at the last minute, that suggests something happened during those 3 weeks. What could make a defense attorney withdraw mid-case, especially this early? In California, attorneys are required to withdraw if the client insists on pursuing a course of action the attorney finds unethical or illegal. If Nick wanted Jackson to do something improper, fabricate evidence, lie to the court, present testimony Jackson knew was false, Jackson would have to withdraw. He couldn't explain why publicly because of attorney-client privilege, but he'd have no choice but to leave. That would fit the timeline and the silence. But that's dark. That implies Nick did something or asked for something that crossed a serious line. And we have no evidence that happened. It's possible. It fits the facts we have. But it's not the only explanation. Here's where things get more complicated. The prosecution in this case is being handled by the Los Angeles County DA's Major Crimes Division. That's the unit that handles the most serious felonies, serial murders, mass shootings, cases with massive public attention. They don't mess around. If they're involved, it means the evidence is strong enough that they're confident in getting a conviction. That doesn't mean Nick is guilty, it means the DA's office believes they can prove it. And if Alan Jackson reviewed the discovery and realized the evidence was even stronger than expected, strong enough that no defense strategy would work, he might have advised Nick to consider a plea deal. If Nick refused, if he insisted on going to trial even when his attorney is telling him it's a bad idea, that could create tension. It could make the attorney-client relationship unworkable. Defense attorneys are supposed to advocate for their clients, but they're also supposed to give honest advice. If Jackson told Nick the evidence was overwhelming, that the best option was to plead guilty in exchange for life in prison instead of the death penalty, and Nick refused, that's Nick's right. But it also means Jackson would be walking into a trial he knows he's going to lose, spending months or years on a case where his client ignored his advice. Some attorneys are fine with that. Others aren't. Jackson might have decided he couldn't effectively represent someone who wouldn't listen. Or maybe it's simpler. Maybe Nick is difficult. Maybe he's unstable in a way that makes legal representation nearly impossible. If he's refusing to meet with his attorney, if he's acting erratically in jail, if he's not cooperating with basic case prep, Jackson can't do his job. An attorney can't defend someone who won't help with their own defense. And in a case this serious, where every detail matters, where the difference between life in prison and the death penalty could come down to how the jury perceives the defendant, an uncooperative client is a nightmare. The thing is, none of this looks good for Nick. Whether Jackson left because of ethics, or money, or evidence, or client behavior, it all signals disaster. If this case goes to trial, and it probably will unless Nick takes a plea deal, the prosecution is going to bring up this attorney withdrawal. They're going to imply that Jackson saw something so bad he couldn't continue. They won't say what it was because they don't know, but they'll plant the idea in the jury's mind that even Nick's own attorney didn't want to defend him. That's incredibly damaging. And Nick is about to walk into court today without representation. If the judge appoints a public defender, that attorney will be scrambling to catch up on 3 weeks of work Jackson already did. If Nick hires someone new, that attorney will need time to review everything from scratch, which means more delays, more continuances, more months of Nick sitting in jail without bail while his case drags on. Either way, his defense just got significantly weaker. Most people missed what happened next. After the murders, after the arrest, there was a brief wave of media coverage. Headlines about Rob Reiner, tributes to his career, shock that his son was charged. Then it went quiet. The coverage dropped off. Part of that is because the case is in early stages, there's not much to report between arrest and trial. Part of it is because the Reiner family has been silent. There's been no public statement from Rob's other children, no press conference from Michelle's side of the family. Just silence. And in that silence, the case was moving forward behind the scenes. Jackson was building a defense, or trying to. The DA was preparing their case. Experts were being consulted. Evidence was being analyzed. All the machinery of a major criminal trial was spinning up, invisible to the public. Now that machinery just hit a wall. Jackson's withdrawal throws everything into chaos. The arraignment today will probably get continued again. Nick will need to find new representation, which could take weeks. That new attorney will need time to prepare, which could take months. And in the meantime, Nick stays in jail, the evidence gets colder, witnesses' memories fade, and the case becomes harder to defend. If you're Nick Reiner right now, today is a disaster. If you're the prosecution, today is a gift. They get more time to prepare while the defense is in disarray. They get to watch Nick's legal team fall apart before trial even starts. They get to make the argument, later, that Nick was so difficult or so guilty that his own attorney quit. The details are unclear here, and they might stay unclear. Attorney-client privilege means Jackson can't explain why he's leaving, even if he wants to. Nick could waive that privilege, could authorize Jackson to speak publicly, but that would probably make things worse. If the reason for the withdrawal is something that makes Nick look bad, publicizing it helps no one. If it's something neutral, like a conflict of interest or a payment dispute, it might not be worth explaining. Either way, the silence is strategic, but it's also maddening for anyone trying to understand what's happening. The prosecution is being handled by seasoned attorneys who've done this hundreds of times. They know how to use chaos in the defense to their advantage. They know how to present a narrative to a jury that says, This defendant is so clearly guilty that even his own attorney couldn't defend him. That's not what happened, necessarily, but it's how it'll be framed. And juries are human. They notice when a defendant shows up to court without an attorney, or with a different attorney than last time, or when there are delays and confusion. It all contributes to an impression of guilt, even if none of it is evidence. Nick is scheduled to enter a plea today, assuming the arraignment goes forward. If he has an attorney, either a hastily appointed public defender or someone new he hired in the last few days, he'll plead not guilty. That's standard. You almost never plead guilty at arraignment. But if he doesn't have an attorney, the judge will continue the hearing again, and we'll be back here in another few weeks or months, still waiting for the case to move forward. The question that matters now is what comes next for Nick's defense. Does he hire another high-profile attorney, someone with the experience and resources to handle a case this serious? Or does he end up with a public defender, someone overworked and underfunded who's doing their best but doesn't have the infrastructure a private attorney would bring? The difference between those two scenarios is enormous. A well-funded defense can hire experts, conduct independent forensic analysis, interview witnesses the prosecution might not have talked to. A public defender's office is stretched thin, handling dozens of cases at once, without the budget for extensive investigation. And then there's the question of strategy. Whatever Jackson was planning, whatever approach he was taking, that's gone now. A new attorney means a new strategy, which means starting over. If Jackson was preparing a mental health defense, the new attorney might not agree with that approach. If Jackson was planning to challenge the evidence, the new attorney might decide to focus on something else. The entire direction of the case could shift, which is risky this late, or early, depending on how you look at it. So where does that leave us? Nick Reiner is charged with murdering his parents in a case that shocked Hollywood and made headlines for weeks. He was arrested the same day, held without bail, and finally got a high-profile defense attorney who immediately delayed his arraignment. 3 weeks later, that attorney is withdrawing under circumstances no one is explaining. And today, Nick walks into court facing 2 counts of first-degree murder with special circumstances, without the attorney he had 3 weeks ago, possibly without any attorney at all. This case was already going to be brutal. Double homicide, famous victims, family tragedy, media circus. Now it's also a mess. And messes don't usually work out well for defendants. They work out well for prosecutors who can point to the mess and say, "See, even his own lawyer couldn't handle this." What do you think happened here? Why would Alan Jackson withdraw from a case like this, 3 weeks after taking it on, right before an arraignment he personally delayed? Drop your theories in the comments. I'm genuinely curious what people think is going on behind the scenes. And if you want to stay updated on this case as it moves forward, because it's definitely going to keep developing, hit subscribe. This is just the beginning of what's going to be a long, complicated trial. Thanks for watching.